Hello.
Thanks for coming.
Hello.
Hello.
Welcome in, everybody. Alrighty, if the defense could take the left side, the prosecution, looks like it's going to be you, Chief, will be taking the right.
Yeah, let me just get everything shared with everybody.
Certainly. The first thing I was going to ask was, do we need a few moments for preparation here?
I'd like to introduce myself.
Yes, we will need a few moments. However, I do have a request, if it is okay.
Is it a pretrial motion or just a request?
It is not a pretrial motion.
Go ahead.
Mr. The Lurker has pled guilty to his charge and does have a fine. However, we are requesting if you would be okay with him doing community service in the courtroom as the bailiff for the court. And if he does not do an adequate job, then he will not get the community service.
Does this man currently have any felonies on his record?
He will be pleading guilty to one, I'm sure.
Then, unfortunately, he cannot function as a bailiff in this capacity as he cannot carry a legal firearm.
What about a
Can
stenographer?
he work as a stenographer?
Yeah, I don't see a problem with that.
Prosecution, are you amenable to this? Is this your goal?
I'm amenable to him working his fine off with community service.
Great. I'll let you know I am a fucking terror as a boss when it comes to stenography because I type at 122 words per minute, so I'm going to be holding you against myself as a standard. Enjoy.
If I could, I will say he does have 2 robotic arms, so would not have much need for a firearm when it comes to being the bailiff. And I think it would be much more funnier.
Well, either way,
More funnier. I think you using a double comparative adjective in my courtroom was hilarious.
Thank you.
I mean, we're not going to listen to you because you used a double comparative adjective. Use correct English next time. Denied. Denied on bailiff. Stenographer is approved if you would like to accept.
This gentleman here is serving community service by performing
Let's
his
talk
duty
later.
as court stenographer,
Understood.
okay?
What's your name?
I want you to make sure that he's actually doing the job. You hear me? I want you to be hard on
Jezebel
him.
Pax. Just call me Jazzy.
Oh, you bet.
Justice
You do
Jazzy.
that?
Jazzy.
Fantastic.
I'll hit you up, Justice Jazzy.
Great.
Hello,
Wait,
madam.
You have to take word for word notes.
Oh, I got this.
Yes.
Our clerk's gonna make sure he's honest. I bought all of the OS for our computers because it had a cute little penguin on it.
Kangaroo court? Can you say that?
That seems like a good reason.
I don't think you can say that.
Please do not disparage the court of Los Santos.
Wait, what did he say? What did he say?
He called it kangaroo
Your
court.
Honor, he
You're a
said
cat
that
eater.
you were
Kangaroo court.
presiding over a kangaroo court.
It was the cat
We
driver.
hear one more thing of kangaroo court. That is actual contempt of court, and
You gotta chill out. man.
will go flying out.
Chill, green hair, chill.
Jesus.
You know what? Defense, are you ready to go?
Yes, Your Honor. I do.
All right,
request that you
prosecution,
open
you've lost your
statements.
last minute. I now call this court to order. I am your Supreme Justice, Mike Kiffa. To my right is Justice Jezebel Pax. We will be presiding over this trial. Apologies. As we are now in session, contempt will begin at $5,000 and go up from there. We will be doing a bench trial today, which means that we will be performing an abbreviated trial, but you are still all expected to behave with decorum. Now that being said, please silence all phones. We will begin with opening statements from the prosecution, then the defense, before moving to witnesses and evidence, finally closings. If there are no questions, then you may proceed.
Hold on, I'm just muting my phone, Your Honor.
I do have a question. Did anybody else hear that cat meowing off to my right?
I
Yes.
did hear a cat meow.
There is a cat that has declared revenge upon Mr. Elias there. We will not be noting anything of it at this time.
Got it.
Your Honor,
Thank you,
defense
Your
does have a pretrial motion.
Certainly. What would your motion be?
We do ask that the charges be read and that my client be given the opportunity to plead to those charges before the trial starts.
Apologies. Yes, that should be done.
Yes.
That's just
all
a part of our job. We'll get to it when we get to it. Don't tell us how to do our job.
Well, that's why I did a motion, Your Honor. Simply ask.
Just to correct here that this is report 66, correct?
Yes, it's report number 66.
That's very ominous.
I know. 600 more, it's gonna be really ominous.
Indeed. You know what's even weirder is I have $665 on me right now.
What the heck is going on in this?
Isn't
What's
that
even
stranger?
stranger here is that I do not currently see charges listed on this report.
There really should be. I'm seeing charges. Are you not seeing charges? Hang
I'm
on.
seeing charges.
You know, he
No,
did
I'm
say he
saying
needed
that's
5
fine.
minutes, so maybe that included finishing the report. Maybe there's something missing.
No, the
I
charges are
believe
here.
there might be a difference between what we can see and what the officer can see.
I believe that
Yeah,
is the
I
problem we
cannot
see here.
see.
Officer,
It's-
could
the
you
charges
please
are
read the
here.
gentleman his
Court.
charges?
Right, he is being charged. Jack Johnson currently is being charged with attempted kidnapping of a government employee and evading. Silas Lenore also charged with kidnapping of a government employee and evading, and he has pled guilty to these charges.
So then we are exclusively hearing Mr. Johnson's case here today, yes?
We are exclusively hearing Mr. Johnson's. Silas has already pleaded guilty. Actually,
Alrighty
he
then.
prefers to go by the lurkers. So I actually do you have a pretrial motion, if I may. In order to make our stenographer more comfortable, his preferred name is the lurker. So if we may all use that.
Yes, thank you.
Henceforth,
First name
when we
the,
say-
last name Lurker.
Yeah,
Correct.
first name the.
So
last name Lurker.
approved. With that in mind, Mr. Jones, how are you pleading to the charges of attempted kidnapping of a government employee and evading?
Not guilty, Your Honor.
Thank you very much, sir. All right, prosecution. If there are no further motions from either side, I would like you to begin with your opening.
All right, very well. All right, ladies and gentlemen of the jury. Wait, we don't have a jury. Your honors.
Hold on.
We do not.
Did you say jury because you chat GPT something from my courtroom?
No, I'm just so used to
I
hearing it.
swear to God, if you chat GPT a single thing in this courtroom,
I would be happy to prove that I do not use that service.
I'll take your word for it now. But if I hear the words jury again, it's gonna sound a
Your
lot like
Honors,
those are the
I
words of
apologize.
GPT,
I
and
just-
you'll understand.
I'm gonna be honest. I've always wanted to say it. That's on me.
Oh, if you
Your
just always
Honors,
wanted to say it,
it's a
everybody
fun
gets one
phrase to
freebie.
say.
Enjoy.
Everybody
Everybody gets one.
Everybody gets
the
one.
gravitas of getting up and saying, you just gotta say it once. All right, thank you for giving me my one. Your honors, the evidence of this case will show that Jack Jones was assisting Silas Lenore, Mr. The Lurker, in attempting to kidnap one of the officers, Officer Sora. Evidence will show that he was at the scene of the crime. He was actively attempting to assist Mr. The Lurker in evading the police. He was absolutely involved in this situation. He absolutely was culpable in the kidnapping of this officer. It's pretty cut and dry, Your Honors. There's not really much else to say about it. Thank you for your time.
Thank you, prosecution. Lots of absolutes. Defense?
Thank you, Your Honors, for being here, and the people in the court. I love seeing people take part of our DOJ. It is refreshing. Your Honors, I fully disagree with what the prosecution has said. My client was not inside of the car with the lurker. My client did not take part in the officer getting inside of the vehicle of their own volition, honestly. My client did not take part in the lurker fleeing from law. All my client did was happen to be in the area and happened to talk to the lurker. My client did nothing other than this, did not try to help kidnap an officer, did not do anything to kidnap an officer, nor did he even flee law enforcement whatsoever, whether on foot or in a vehicle. And I believe that you will find him not guilty today.
Thank you, defense. With that then, prosecution, it is now your time to call witnesses. Who would you like to call?
I would like to call Officer Sora up to the stand, if you would be so kind. Just for the records, his full legal name is Ren Sora, Officer Ren Sora.
Will you please swear in Ren Sora, Jazzy?
I was gonna ask if I could. Thanks, boss.
Please
All
do.
right, please raise your left hand real high into the sky for me.
What?
Do you swear and affirm the testimony read is the truth, the whole truth, and nothing but the truth, and pains and penalties of perjury up to and including death? So help you, Katie Cat.
I swear.
Kitty cat.
The witness has been sworn in, Your Honor.
I do.
Thank you. Your witness, prosecution.
All right. Officer Sora, how are you doing
Yes.
today?
Well, I've been better.
All right. Why don't we begin with how this started? Tell me, in the report, it says here that you were outside of the courthouse,
It was.
or the police station. Apologies. And you were dealing with an individual. Can you tell me a little bit about this individual?
I believe his name was the Red. rocket or something like that.
Oh.
Definitely super villain. He was shooting laser out of his eyes, and this is when um our the Scourge, what was his name?
I don't know. You tell me.
The individual sitting to my right.
Are you attempting to refer to the judge or Mr. the Lurker?
Mr. the Lurker. That's his name.
Okay.
He pulled up in his car, him and Mr. Jack, and asked for car troubles fixing. Now,
Fixing
they
their
said their engine was in the rear of the vehicle, one of those hybrids, so I offered to help.
And allow
They
me to
told
stop
me-
you right here real quick. Just to confirm, you're saying that Jack and Mr. the Lurker were together. at
That's
this time,
correct. Yes.
And they both.
What's
I
your
would like to
objection?
object. He is leading the witness in that question, and I would like it stricken.
What are your thoughts on that one, Jazzy? 'Cause it sounded confirmatory to me.
Boss, you're gonna need to tell me what they were saying because I was actually posting on Birdie to let everybody know that this court case was happening because I wanted everyone to know that they should come here and witness the first case happening to witness history. So what did they say?
So the prosecution just stopped the narrative of the witness to confirm that they said that 2 people were in the car. That sounds confirmatory to me. It does not sound like it is leading in nature necessarily, correct?
They were asking a
It
clarifying
was clarifying.
question.
That's the words I was looking for. Thank you.
Yeah, clarifying questions can be asked in a leading
It
manner.
is not muted their phone.
They shouldn't be, and there's a
I
way to
believe they
ask
could
it that is correct. So it depends on how they asked it exactly.
He asked, just to confirm here, you said that they were both in the car.
That's the definition of leading.
Okay, that's what I thought too. Okay, that's why I was asking in the first place. That objection is going to be sustained. Please rephrase the question, prosecution.
Very
Thank
well.
you, Your Honors.
Could you repeat back what you just said? Who does
There
not
you
have their
go.
phone muted?
There you go. Yeah, who are the flapperjacks? Not putting
believe
another
that
cord
be
on the
the,
swear jar
witness,
today.
Your
Who are
Honor.
the flapperjacks?
Sora, do you not have your phone
For the
muted?
love
I
of
do. I have it on
Christ.
airplane mode.
Okay, then it's not.
Who's getting a phone call right now?
My phone is also in airplane mode.
For the love of the Protestant Christ, please put your phones on silent.
If I hear a phone going off again, I will be issuing contempt.
Boss,
Your
it wasn't
Honor, I do
leading.
not
He
hear
can
a
do
ringing
confirmation questions. He can do clarifying questions. It depends on how he does it. We're gonna let's not be annoying.
I agree with that. That's why I wanted to confer
Yeah.
with you. We will not be
Yeah, good,
annoying
yeah.
and allowing the question. Please continue.
Okay, so just to clarify, the question: can you confirm that it was Jack Jones and the Mr. the Lurker was allowed and is on the record?
It was both of them.
Okay.
Great.
And so they asked you, could you please continue your story?
They asked for help with their engine troubles, and I, as a public servant, deemed it appropriate to help. They said that the engine was in the rear of the vehicle. I'm not familiar with these hybrid cars, so I looked in, and that's when they shut the trunk on me and drove off.
So, you were checking the engine of this car. You were put into the trunk, and it was driven off.
Yes. May I add, there was in fact no engine in the back of the trunk. I was stuck in the trunk for a bit until I figured out how to free myself. At that point, I came out, and Mr. God damn it, the Lurker? What is it? What is your name?
Mr. the Lurker is his
Yes,
preferred
Mr.
name.
Mr. the Lurker was already in cuffs at said time, and Mr. Jack arrived on his motorcycle.
And just okay. So Mr. Jones arrived on his motorcycle to the
Yes.
scene of Mr. the Lurker being apprehended.
Indeed,
You said that you were in the trunk of the vehicle, correct?
that is true.
Did you see who got into the vehicle?
Mr. Lurker was already in the vehicle as before they drove off.
Gotcha. So can you confirm whether or not Mr. Jones was in the vehicle when Mr. Lurker or the Lurker drove off?
I cannot confirm. I couldn't see into the car.
I see his angle. That's a
Okay,
good
and At
angle.
the time of you getting into the trunk, was Mr. Jones in the vehicle?
He was not. He was
Objection,
towards
asked
the
and
rear.
answered.
What was the
If I may, Your
objection?
Honor.
Sorry, I spoke too fast. Asked and answered. He already asked this question a couple seconds ago.
If I may, Your Honor.
Yeah.
Please
I
rebut.
did not ask this question. I asked if he could verify who was in the vehicle. This is a different question entirely.
Objection overruled. Proceed.
All right,
Yep.
very well.
Thank you. Can you please answer that?
At the time of me entering the trunk, Mr. He was towards the rear of the vehicle. He was not inside the car. No.
Perfect. Thank you. And when you got out of the trunk, was he inside the vehicle?
When I got out of the trunk, no one was in the vehicle.
Got you. Was he on scene at all when you got out of the vehicle?
Yes, with his motorcycle.
Ah, I understand. And you said earlier in your previous testimony that he had driven up to the lurker. Is that correct?
That's perfect.
That is true. Yes.
I have 2 questions, Your Honor.
Go right ahead.
Can't wait.
My first question, to clarify, did he leave the scene?
He did not.
In your previous testimony, you said he did, though.
They said he drove off, but he did not leave the scene. He was still on the same block.
Your Honor, if we could ask the stenographer to read back, I'm almost positive the officer here stated that he left the scene but then came back.
I can actually help you out with that. The officer's specific words that were that he sped off, but then later came back. And the specific clarifying question or confirmation, borderline leading by the officer, was confirming that.
Perfect. Thank you, Your Honor.
Defense, do you have any witnesses you wish to call forward?
Yes, Your Honor. I have availed my client of his Fifth Amendment rights, but he would still prefer to testify.
Understood.
Can you please state your full name for the record?
Yes, Jack Jones.
And to confirm, it is not Jack Johnson.
Correct.
Perfect.
I have
Thank
never
you.
been and never will be called Jack Johnson.
Thank you for clarifying.
I'm afraid we will need one more clarifying question from the bench. You've never been associated with anything close to a band, have you?
Negative.
All right, just making sure. Thank you. You may proceed.
Now, Mr. Jones, were you around when this situation occurred today?
Yes.
Were you at the scene?
Yes.
Did you stuff an officer inside of a trunk?
No.
Did you get inside the vehicle that the officer got into?
I was never in that vehicle at any point.
Perfect. Did you participate in the pursuit?
Not directly.
Perfect. Were you there when the vehicle crashed?
No.
Did you drive up on your motorcycle after?
Yes.
Did
Just
you
letting me know there's
ask
so many leanings.
the lurker to get on the motorcycle?
No.
What were you doing?
Talking to him as a friend.
What were you talking about?
About him being potentially charged.
Understood. At any point, did you want the lurker to get on your vehicle?
No.
Did you surrender yourself to law enforcement officer?
I never got the chance to. I was
Understood.
tased and put in handcuffs.
Oh, I understand. Earlier, an officer said that you surrendered willingly. Is that correct?
I was never asked to surrender.
Ah,
But
I understand. No further questions, Your Honor.
Hey, I'm striking your last question as a leading from the bench. You're on direct. You know better than that.
Your Honor, if I may,
All right.
I didn't object to the 17 different leading questions that prosecution asked. If I could have some leniency, I
Yeah,
would
but you
appreciate
expect the cops to be dumbasses, don't you?
No,
No
let
offense.
him have this. Let him have
I'm not
this.
gonna
Trust.
This is
answer
not
that
my
out of
primary
professional
form of
courtesy.
employment.
Yeah, but let me make him fight for it. You know?
He's
I'm okay
that's
with
fair.
that.
He's
I'm
fighting
okay
for
I'll-
a good. Allow
I'll
it.
give it to him,
Let the
but let
record
me
show
make him
that's
fight
fine
for
with
it.
me.
Okay, acceptable. Go for it.
I can rephrase it if you would prefer, Your Honor.
Tell me how you'd rephrase it.
Honestly, I'm not gonna lie, I don't actually remember my last question.
I'm gonna let you know right now. You didn't need it. The statement right before you just you were. Hold on.
What was the last question, Your
Yeah,
Honor?
I also forgot the last question.
I can clarify. I wrote it down.
Oh, look who can help.
Stenographer, please read it back.
Go ahead and do the instant replay.
So the lawyer asked, "Did you surrender yourself?" To which Jack said, "Never got the chance. I got tased and put in handcuffs." The lawyer then asked a slightly different question. Earlier, an officer said you surrendered willingly. Is that correct? Which I would,
That's the
I
one.
would, I would posit is not leading because it is technically a different question, but that is not my job.
Yeah,
he
it has
said,
nothing to do with the
earlier officer
difference.
said this. Is that
Oh,
correct?
I can easily rephrase that then.
Go ahead.
Earlier, an officer testified that you willingly surrendered. Was that statement correct?
No.
That was
Thank
it.
you,
the chance.
defense.
Literally, that's how you do it. That's how you do it. Yes or no are not always leading. That beautiful.
All right, with that in mind, would prosecution or defense request any recess at this juncture before we go on to closings, or are you both ready?
I think
Defense
I
is
may need to
prepared.
take a nap, but I can do that after, Your Honors.
Defense?
Actually, Your Honor,
Yes,
defense would like to call a witness if that's okay.
certainly.
Yeah.
We would
Are
like to
they
call
here today?
The lurker.
Oh, shit, my time to
Oh,
shine.
I was honestly waiting for this moment.
Now, Mr. The Lurker, were you involved in this situation?
Yeah,
Did you see everything that occurred?
yep, pretty much all of it.
When the officer got into the vehicle, was Mr. Jones in the vehicle?
Like in the car that I was allegedly driving.
Yes.
No.
Perfect. And did Mr. Jones ever get into that vehicle when the
One
officer was
moment,
in
real
there?
quick, defense. Just to clarify here, Mr. The Lurker, you have pled guilty to charges of attempted kidnapping pertaining to this incident, along with the evading, yes?
Yes.
Okay, then there is no allegedly about it, sir. You have pled guilty. All right, continue, defense. Apologies.
You are fine, Your Honor. Thank you. Now, did Mr. Jones ever get in the vehicle after the officer got in?
No.
Did Mr. Jones try to help you get the officer in the vehicle?
No.
When you came back and unfortunately crashed, did Mr. Jones tell you to get on his motorcycle?
No. I got on my own free will.
Why did you do that?
I was trying to escape, and I knew that he would be leaving the scene as he had no relevance to be there, and so I was taking advantage of that.
All right. Thank you, Your Honors, for your valuable time in this matter. My closing statement would be this. Mr. Jones was offered ample ability to leave the scene of his own volition. He stayed. He attempted to help his client, as he claimed, to escape from the police. He attempted to argue on his behalf as a lawyer. He was warned multiple times to leave the scene. He refused to do so. He was not cooperative. And I believe that he should be given his full fine and time. Thank you so much, Your Honors.
Defense.
Thank you, Your Honors, for taking this case. We greatly appreciate you overseeing justice today. While I understand where the prosecution is coming from, I do not quite appreciate when they try to bring things into the court in their closing that were not actually talked about. Not once was it actually testified to that my client said that he was a lawyer, nor that he said that Mr. The Lurker was his client. None of that was testified to because I expertly objected to it, and it was stricken. Secondly, we had two different witnesses state that Mr. Jones not once helped get the officer into the vehicle. Mr. Jones was not in the vehicle when the officer was kidnapped. Mr. Jones did not take part in the kidnapping at all. We also had Mr. The Lurker, who have already pled guilty to these crimes, specifically state that he was never once told that he would be given the opportunity to get away with Mr. Jones, with Mr. Jones' statement saying that the only reason why he moved his motorcycle at all is because he got scared because somebody got on his bike and he was not expecting it. The only officer brought forward that gave testimony today didn't even see if Mr. Jones was in the vehicle. I do not believe that there is any way to find Mr. Jones guilty of these charges, as no evidence at all has been provided to show that he assisted or even took part in this kidnapping, because he's being charged with the principal and not accomplice. And he did not evade at all. Thank you, Your Honor.
Alrighty, with the both of you having completed your closing statements, we will now go into the back and deliberate. We ask that all of you maintain decorum while we are back there. We should take no longer than about, let's call it 10 to 15 minutes. However, before I do so, Mr. Interim Clerk, you have one more duty while we do this, and then you shall be released. I believe your community service has been most gracious. Pending, I would like you to provide your notes to the clerk to your right, and I would like her to verify them while we go back and deliberate.
Great work
Thank
on
you.
instant replays. Yeah, great work on that. Kudos.
There you go. All right. So my thoughts here, honestly, are not guilty, not guilty. That guy gets to go. And here's why. If they had had false impersonation, that would have been something. But they did not push it. But they need to learn that they need to push those things if they have enough evidence for it. However, I don't think they proved that the guy had any kind of actual accomplice, or let alone actually being the primary on kidnapping of a government employee. And I don't think he evaded. There was no chase. There was no pursuit.
Hold on, boss. Hold up. Walk me through everything you just said from the top, because I think I've got comments and questions.
Okay, so attempted kidnapping of a government employee. I'm looking at the charges that they are charging, because we do not change charges in this state.
Well, did what's his face plead guilty to it or not?
The other guy pled guilty to it. Yeah, he did it. The other guy, the lurker, he did it.
Yeah, so we do have a principal who pled guilty, yeah?
We have a principal who pled guilty.
All right.
They're not charging this guy with accomplice, so that already creates a problem. But further problem here, I don't think that they've directly tied
What
him.
did they charge him with? Did they charge him with principal too?
Principal, yes.
Oh, they're stupid. They would have the easiest accessory here in the entire world.
They
Well, I
did
think
not
we
charge
can
him with
drop it.
accessory. We
No, here's
drop
the
it.
thing. Here's the thing. I think we can drop it. Here's the thing. I think we should reserve the right, and we can drop charges when justice calls for it, right? Okay? But that doesn't mean that we always do.
One.
Thank you all for waiting. I do apologize for the time that it took us to come on out here. We wanted to make sure that we reviewed all of the facts and evidence presented before us by both sides today and came to a unilateral decision upon how we wish to rule on this now and going forward.
All right, boss, you're fine. I see. You're going to allow them to get the actual understanding of how and why we ruled the way that we did on the specifics and when for after. All
Precisely.
right, go ahead. It's perfect.
Today, we have heard some interesting statements. Both sides have definitely made some compelling arguments. We will offer a period for questions after the verdict is read. However, a few specific facts that came before the court today are going to be the determiner of our verdict. Firstly, we found that the officer's testimony to have contained multiple contradictions that brought into doubt whether Mr. Jones ever even left the scene of the incident. Furthermore, we are unaware as to whether Mr. Jones was detained at this time or any other such variables. We also have heard one Mr. the Lurker state under oath that he has attempted to exploit his friend in what may call a cruel or even evil way today. We have heard from both sides that Mr. Jones was not inside the vehicle that kidnapped the officer and was instead in possession of a second vehicle. Now, while the court finds it very concerning that Mr. Jones may have falsely identified himself as a lawyer, and that there may have been lawful orders disobeyed, the court does not see fit to change or alter the charges brought before it today, and would advise the defendant to refrain from such behavior in the future. With all of this understood, the Court of San Andreas does find Mr. Jones not guilty of the charges levied against him today. He is to be immediately released. Thank you.
Thank you, Your Honor.
I will
Yeah.
noted in the report.
Also, Chief, while you're at it, Mr. the Lurker, I do believe, has served his community service. I believe the fine should stand, but he is not needing to be going up for any time.
Badass.
Your Honor, the original conversation was for us to be in lieu of the fine.
Oh, in lieu of the fine as well? My apologies then. I will honor
he
that.
should not have been charged for any of it. And, you know,
My apologies then. I
Fantastic.
will honor it. Then no time, no fine.
Thank you, Your Honor.
We do want the officers to
Chief.
know
We
his
do
notes
appreciate it.
were impeccable. He actually did a phenomenal job.
hell yeah.
We checked his
So
work.
he was working, yeah. We checked his work. It
Well,
was
you,
stellar.
Mr. the Lurker, you might turn your lap around after all.
Well, I don't know about that.